one of our values is that we've got to be very effective and we've got to get through the work on time, that justice delayed is justice denied. And I'll give you an example, which I think is very relevant for those of you in the public sector, which is about freedom of information. You know that when you get an application for access to information under the Freedom of Information Act, if after you've done your investigation and you've had your internal review, the requester is still dissatisfied, it comes to the Information Commissioner to decide. And in the first 5 years of administering the Freedom of Information Act, we found it very difficult to keep up with the business. I think everybody found it very difficult to keep up with the business, but after 5 years, we really should know how to do it. And in the past 9 months, we have radically tackled the huge backlog of freedom of information appeal cases. One of our sternest critics, who we'll be hearing from this afternoon, Maurice Frankel, talked about the Information Commissioner's Office, which, as you know, is based up near Manchester, in a place called Wimslow. He said, it isn't Wimslow, it's Slow Wim. Well, I'm afraid we're destroying that line for Maurice, because we completed more cases in 9 months than we'd done in the whole of the previous year. We've closed down all the embarrassing cases that dated from 2005, 2006, 2007. When we publish the annual report in July, we should be pretty much up to date, in as much as one can be up to date with something as complicated as dealing with these weighty freedom of information matters, which only get to us because they are complicated and intractable. How have we done this? Well, we've not done it by sacrificing quality for quantity. You'll find that the decision notices that appear on our website are just as well thought and well argued as before. And if there was any suggestion that we were cutting corners, we would be in trouble with the Information Tribunal, which is the appeal level, and that isn't happening. There are a lot of appeals to the Information Tribunal, but then we're publishing a lot of decisions. But there aren't a disproportionate number of uphelds from the Information Tribunal, which is the test. Now, it's very important for an organisation like the ICO to hold to better regulation principles. And an important matter for an effective regulator is to get the balance right between education and enforcement. Education, the upstream activity, helping people like you to get it right, whether you're managing information rights on the data protection side or the freedom of information side, or both. That's another reason for integrating at the ICO, because very often we're dealing with individuals in local authorities and the health service and in the education sector who are responsible for both. And it was a bit bizarre to have one person appearing from the ICO talking about freedom of information on Monday and somebody completely different the following week talking about the other side. But the upstream activity is where we're placing our effort. If you look at our draft corporate plan on our website, you'll see that we're investing in guidance and help, and that is a service for the many, and the enforcement, which one hopes is going to apply directly to the few, is something that I'm not downplaying, but it shouldn't be the major focus of our activity and the bulk of our expenditure. If we get that balance right, it's a much better use of our time and resources. It's much more helpful. But, ladies and gentlemen, you should be under no illusion that just because I'm not emphasizing enforcement as the major activity, it isn't there, because it is. The big stick is there. It just got bigger. We've got powers and penalties under the latest legislation that give us a fallback which is very effective. And colleagues would do well to bear in mind that the Information Commissioner is now armed with civil monetary penalties of up to £500,000 for serious breaches of the Data Protection Act. Doesn't mean that I'm going to go around fining everybody £500,000, but I'm saying that's the potential. It's there. And a proportionate, better regulation approach means that when we've exhausted all possibilities of being helpful, we will get out that big stick, and the clever ones among you will make sure that it isn't you. We've also got powers of audit in the public service, assessments they're called, and we're very, very glad to be invited in by organisations to give an assessment of how you're coping with data protection or freedom of information. But we now have the powers in the public service to come in unannounced, to audit you against your will, if you like. Now, the reference was made to being tough. There is a balance. I'm keen to be helpful, but the help has got to have behind it a real understanding of what happens to organisations that don't take this sort of thing seriously. But again, I can give you a for instance. We've had all data protection and privacy authorities have over recent months had issues with some of the big international providers of online services, and one of them is Google. We had occasion to write to Google about a service they launched called Google Buzz, where they simply hadn't thought through the privacy implications of that, and all the privacy commissioners together faced Google with that. We've had another issue this week where Google have fessed up to the fact that in course of devising Google Street View, they acquired a certain amount of personal data from Wi-Fi. Now, this was a reported breach to the Information Commissioner's Office. The information appears to be very, very bitty. You couldn't make very much sense of it. We have instructed Google that they ought to destroy that information forthwith. But there are campaigners, and maybe some in the room, who are very critical of the ICO for not being sharp enough and smart enough. We were accused of being 10 steps behind the pace. Ladies and gentlemen, we're making sure that in our restructure, we are staffing up so that we are technically equipped to keep up with some of the developments in the online world. But I don't believe it makes sense to order a company that's fessed up to a breach to retain information just because somebody else wants to launch a prosecution. We have got to take a balanced approach, and I think on this occasion we got it right, but it won't make us popular. Finally, what does all this energy and excitement at the ICO mean for people like you? Well, it really does mean that you're going to have to take the ICO seriously. I know you do, but if you thought you were dealing with an information commissioner that was going to take a long time to get round to your case, you're wrong. We are getting out of a vicious spiral of delay and difficulty and postponement, which invited public authorities to kick issues into the long grass in the hope that they would stay there. The big departments of state heard me at Sir Gus O'Donnell's Wednesday morning meeting a few weeks ago make the case very clearly that if that was ever a strategy to game the system, it isn't going to work anymore because we're on your case very fast.